Bill Henshall here again for the Constitutional Crisis channel. This will be one of our longer and more detailed videos, and we're starting to do those now. Subject matter will be Habeas Corpus and the revised statutes. At the outset, for those of you who don't know, Habeas Corpus is a Latin phrase meaning that you have the body, which usually means you have the person in custody who's the petitioning for the writ, but you don't have to be in custody. We'll get to that part later. But that's what it means. You may have seen it used in a different context that comes along every so often. You know, where the head cardinal comes out there on the balcony at St. Peter's Square and declares to the masses below, habeas papam, which means we have a pope. And, you know, so it's been in use there too. It comes into play, and of course the Latin is the language of the Catholic Church, so it kind of makes sense. Anyway, that said, what I'm talking about here with the revised statutes are the revised statutes of 1875. And they are such a joke you can't believe. And I'm going to have a separate paper on this. It will be available in my document package. You can ask about by email at ccaspari@live.com. That's CCASPARI at LIVE.com. And you won't believe what they did here. And this, basically, these revised statutes are the factual foundation and legal basis, quote unquote, for the existence of all the statutory writs that you will find at 28 U.S.C. 2242 through 2255. And what doesn't come from there is derived from the War Acts of Congress in the 1860s. The first Civil Rights Act, for example, the Reconstruction Act of 1867. This is where all these statutory writs come from. War powers, federal, regional, martial law rule. We can prove it dead bang with what's in my document. You're going to be stunned when you read this stuff. So what that means is that we go into courts and petition for a writ. It's a non-statutory common law writ. That's secured by Article 1, Section 9, Clause 2 of the Constitution of the United States that says that Congress can't suspend the writ except in cases of rebellion or invasion where the public safety may necessitate the suspension. I've been looking around 4 decades for a declared state of rebellion or invasion. I haven't found one. Therefore, they can't do it. In addition, if you want to cite a statute, and this one's safe to do, you cite the first Judiciary Act of 1789, Section 14, 1 Statutes at Large 73. You can Google this, it'll pop right up. That's the writ we want. And the good news for us is that the Supreme Court has said, in cases right around the same time as the revised statutes, although slightly before them, is that the laws they had just enacted, and one of them was the Habeas Corpus Act of 1867, did not apply to these common law writs. Wasn't relevant there because they were there, what they call ex proprio vigere in law, by their own force, by the force of the Constitution. We're not limited to their statutory writs, and they're right. A big case on this one is called Ex Parte Yerger, Yerger, 8 Wall 332. I'll get you a fuller cite in the notes below. Read those, it'll be in there. And the court explains, and don't think that's a big difference. Had the writ come to the court in the case of Ex Parte McCardle, McCardle, at 7 Wall 506, with the full citation below. And these attorneys brought it under the Habeas Corpus Act of 1867. And what happened here was the Supreme Court took the case anyway, heard the case, decided the case 5-3 against the Reconstruction Act, but were not allowed to announce the decision because Congress passed an emergency statute, and it was one hell of an emergency, and took jurisdiction away from the Supreme Court, which on the appellate side they can do. If they had done what Yerger did about 1.5 years later, this wouldn't have happened because they came with a common law non-statutory writ. It got issued, Yerger got set free. That's what should have happened to McCardle, and had that happened, now, the Reconstruction Act is off the books, and the 14th and 15th War Amendments are off the books too, because the southern states that ratified those were not in proper exercise of the authority of states when they did it. That's what they can't beat, and that's what they don't want you to know. So you get to these revised statutes, and the big deal here is that when they did this, they had a lot of other business to do at the time, as you might imagine, and it was decided by whom I don't know, but they would only deal with the revised statutes in evening sessions in which none of the members were technically required to be actually present. As a result, you had times throughout this process where you had 289 members of the House at the time. You might have had 30 or 40 of them at a given session on these revised statutes. Nothing anywhere close to a quorum to do business, to decide whether they could do these changes to start with and decide whether they had the authority to enact them. I mean, that's how bad this was. And there's a long quotation you're going to see in the document that I have on this from a representative from Wisconsin that calls attention to what he frankly called a fraud, a sham, and a lie to the American people, that they were being led to believe that the Congress of the United States was here, ruling on these revisions to make the revised statutes. And he says that's a lie. The House of Representatives is not here. This beats them, because if they're going to say that we're limited to these statutory writs, they're going to have to overcome these objections, and they can't do it. That means our writ, just as it was in 1789, is still available, and it must be. What we have to do is find judicial courts in which they can issue, and I'm now taking the position that when we go into a court, no matter what it is otherwise, our appearance converts it to a judicial court. It's our court. Framers of the Constitution recognize this under Article 34 of the Magna Carta, signed 800 years ago in 1215, where it said that a free man had the right to his own court. That's what it is that we should be doing, and going in there and making our own courts and taking it away from them. It's about damn time we start to do that. And no sooner that starts to happen in one place, it's going to happen in others, and it will spread across the nation. And we will then be in the process of getting back our federated republican government of defined and limited powers based on the rule of law and the quote-unquote consent of the governed. And we can do that, especially using this document I'm going to have on the revised statutes. It shows clearly and unambiguously that they can't be counted upon for anything by way of authority to deny your writ. Another real good one you're going to look up in this regard is Ex Parte Merryman, Merryman. I'll get you the site for this one below. It came in 1861, written by Chief Justice Roger Brooke Taney, for my money, the best Chief Justice we ever had. And this was right at the outset of the war between the states. It really had just started, and they arrested John Merryman in Baltimore on the grounds of seditious libel and also as a traitor to the country. And the problem with that was, though, that habeas corpus hadn't been suspended, which Lincoln did, I believe, in 1863, and he didn't have any power to do it. That's a story for another day. But McCardle, they came to his house at like 2 o'clock in the morning. This is 1861. I mean, this doesn't happen. Hauled him out of bed, took him into federal military custody, and he had the sense enough to write out a writ of habeas corpus that got to Chief Justice Taney, who wasn't acting for the Supreme Court at this time. He was the Circuit Justice, and the Chief Justice is still the Circuit Justice for the Fourth Circuit, where Maryland is. And he wrote this opinion and ordered the general, his name was Cadwallader, to produce the body of Merryman at a hearing to find out whether his detention was legal. Cadwallader refused, and Taney thereupon issued an order to hold him in contempt of court. And the matter kind of ended there because Taney recognized the position he was in, that he said he had done all he could do, but he was overcome by the odds against him since the nation was beginning to get into the war between the states. He wasn't getting any support from President Abraham Lincoln, which he should have gotten, and therefore he would have no way to enforce the orders that he would have issued in the case of Merryman. I mean, this one, you can Google this, by the way, Ex Parte Merryman, it will pop right up. And there's 8 or 10 cases you should be real familiar with. This is one of them. It's not a long case either, but it talks about the writ and what you have to do to get it. And Merryman should have gotten one. Should have been set free. But this opinion was everlasting. I mean, one of the 10 best I think the court has ever done, even though it's not a Supreme Court decision technically. But it's in my top 10 list of decisions made. And you should get real familiar with it. So that said, in concert with what we've been talking about with the revised statutes, that means that they can't tell you that you're not entitled to the writ that we're going to present Because if they do that at one and the same time, they're saying there is no Constitution. And I don't think they can afford to make a statement like that to the American public. If they do, we'll take care of business and we'll fix it. The other thing about that, more troubling to me personally, is that the people behind the scene that you don't see at 120 Broadway, New York, among other places, are saying, in effect, we don't care, we're going to tell you that anyway, and there's not a damn thing you can do about it. This brings on the concern in my part that they not only may think that there will be another Tiananmen Square here, they may already have planned it. That's how serious this habeas corpus business is, because it's the only remedy we have that we can force upon them and make them adhere to their oaths of office and restore the Constitution and the Republic and the nation that we have here, and get rid of all the civil rights crap and federal, regional, martial law rule. Now, with the matter of the writ of habeas corpus, another contemporary case of great importance to us is the case of Ex Parte McDonald, which is 16 federal cases 17. That one's going to be hard to look up. If your law library happens to have the set of books called Federal Cases, and they may, if it's a good one, it'll be right in there. There's 30 volumes, and they're really thick, too. They're big, long books. But 16 Federal Cases 17. If you can get online on, like, Lexis and Westlaw, you can type that right in, 16 FC 17, and it should pop up, or 16 FED period CASE 17, and it should pop up. Because this is the case where the judge said, in rejecting the government's argument that they could produce a limited suspension of the writ, he said, well, if you can do that, you can, in effect, suspend the writ without just cause and for any reason or no reason, and that's beyond the scope of the government to do. If you can do that, there's no writ of habeas corpus, and in effect, though he didn't say this at the time, there's no Constitution. That's how important this is. Get real familiar with this case. I'll have it available for you in digital form as soon as I can get it. Thank you.